I will now call this meeting to order of the Senate Judiciary Committee. It is April 27th of the 81st Legislative Session. Would the Honorable Secretary please take the roll?
Vice Chair Cannizzaro,
She will be here soon. Please mark her present when she arrives.
Senator Orenshaw,
Here.
Senator Harris,
Here.
Senator Settlemeyer,
Here.
Senator Hansen,
Here.
Senator Pickard,
Here.
Chair Scheibel.
Here. All right. Everybody is here. We are going to take things slightly out of numerical order today, and we will be starting with Assembly Bill 237. I will now open the hearing on AB 237. And while we are getting situated here, can I just confirm that we have Brad Spires on Zoom and Michael Buckley and Joel Just? Okay, perfect.
Thank you, Chair. I appreciate your patience. We have two components to the bill, and I wanted to make sure all my speakers were lined up, my co-presenter as well. Good afternoon, Chair and members of the Committee on Judiciary. For the record, I am Sandra Howdigi, representing Assembly District 41, and I am here today to present Assembly Bill 237 for your consideration. The genesis of Assembly Bill 237 was a result of Assembly Bill 335 from the 2019 session, which made it out of both houses with unanimous support. Assembly Bill 335 was introduced in partnership with the Community Association Management Executive Officers and the Nevada Association of Realtors, something we worked on together for nearly 18 months. Assembly Bill 335 accomplished two things. One, it streamlined the residential selling process for the organizations who do the behind-the-scenes paperwork, the title and escrow companies. Two, it established timelines and uniform fee caps for HOA resale packages, HOA demands, and HOA transfer fees. We are here today to clean up language regarding HOA fees from Assembly Bill 335. Assembly Bill 237, which you have in front of you, will add in language to clarify that association companies can't charge resale closing fees other than those laid out in statute. Once Assembly Bill 335 was passed and signed into law, we saw junk fees begin to emerge that had never been charged before. Assembly Bill 237 will also address an omission from Assembly Bill 335, which adds the CPI increase of no more than 3% to the transfer fee. We all agreed we would add on to all three fees, the resale, demand, and transfer, and during drafting, we accidentally left it off of the transfer costs, so we are just adding it back in. New to this bill is an enforcement mechanism. Assembly Bill 237 will also give the CIC Commission the ability to impose a fine of not more than $250 for associations who are in violation of the fee structure. The reason we added this in is due to the fact that associations continue to charge more than they are statutorily authorized to do. I have on two personal occasions signed home buyers where an association was charging $100 and $150 more than they were statutorily allowed to on the transfer fee of an HOA from one owner to another. This will give the Commission the authority to enforce the laws that we passed as a body in 2019. Chair and members, I'm here today with the associations and the realtors who don't often come to the table together, but the association management companies and the realtors are here to show that this was a bill that we all in good faith worked on for many years now and want to make sure that it's fully implemented to its intent. I would now, Chair, with your permission, like to turn it over to Rocky Finseth, and after Rocky, we can go to Joel Just with the Community Association Management Executive Officers, and then Brad Spires on behalf of the Nevada Association of Realtors.
Chair Scheibel and members of the Senate Judiciary Committee, my name is Rocky Finseth, R-O-C-K-Y F-I-N-S-E-T-H with Career Nevada. am joining you today on behalf of the Nevada Realtors to discuss AB 237. Joining me today on Zoom is Mr. Brad Spires, President of the Nevada Realtors, along with Teresa McKee, our CEO for the Nevada Realtors. On behalf of the Realtors, we would like to thank Assemblywoman Howdegui for working with us to bring this bill to all of you today. The measure is an important piece of legislation for the Realtors across this state, as Mr. Spires and Ms. McKee will outline to you shortly. We'd also like to acknowledge the outstanding partnership with Cameo, the association managers for HOAs across Nevada. We appreciate the long-standing working relationship that we've had with them, their willingness to sit across the table from us to resolve and work through many of the issues that we're going to discuss with you today that have impacts on consumers who choose to purchase homes in HOAs. Chair Scheibel, with your permission, I think we'll go to Mr. Just next, and then President Spires. Thank you.
Thank you, Madam Chair and the members of the committee. For the record, I am Joel Just, Joeljust. I'm the current president of Cameo, which is comprised of HOA management company executives. I want to thank Assemblywoman Howdegui and the Realtors for all their help in addressing industry concerns, as laid out before you in the Assemblywoman's amendment. We are strongly in support of the amendment, which in our opinion will continue on the Assemblywoman's hard work of rooting out bad actors in the association management world and allow professional organizations like Cameo, whose members play by the rules, to continue to make their HOAs the best they can be for each and every homeowner. We are grateful for the ongoing partnership, not only with the Assemblywoman, but with the Realtors who sit around the table with us year in and year out and work collaboratively finding solutions for mutual issues. The members of Cameo fully support this amendment and by extension Assembly Bill 237. Thank you.
Thank you, Mr. Just. Chair, with your permission, I'd like to go to Mr. Spires, President of the Nevada Association of Realtors. Mr. Spires?
Thank you, ma'am. For the record, Brad Spires, S-P-I-R-E-S. I am the president of 18,000 practicing realtors in Nevada, and we're really pleased to be here to testify in support of AB 237. Assemblywoman Howdegui, thank you so much for the time you've spent on this, and it's been a terrific outcome to this point. We appreciate the Cameo and the ability to work together there. This proposed amendment really is a reflection of an enhancement for the community and for consumer protection. While the majority of the association managers are professional, consistent in providing their services, we've had some issues with some of the smaller managers. Just an example, in Gardnerville, in a small HOA with only about 80 homes in it, where the monthly fee was $100 a year, the association manager charged $600 for a transfer fee. So very few of those folks that participate, by and large, they're all really good. The dilemma comes when that fee comes in late and it's at the table and it's time to close, and they really don't have any other option than to go ahead and pay it because they don't want to hold up closing. So we agree with the fee structure, and we think it's a really positive step, and thanks to Cameo and thanks to you, Assemblywoman Howdegui.
Thank you, President Spires. Now, Chair, I would like to turn it over. Take two. Now, Chair, I would like to turn it over to Maggie O'Flaherty, and then followed by Michael Buckley on behalf of the Real Property section of the bar to walk you through the remainder of the bill. The Real Property section of the bar needed a vehicle for cleanup language to their section of the NRS, and I was happy to provide Assembly Bill 237 to accomplish this.
Thank you, Maggie O'Flaherty with McDonald Carano for the record here today on behalf of the Real Property section of the State Bar. Thank you, Chair Scheibel and members of the Senate Judiciary Committee. The section would like to acknowledge Assemblywoman Hadigi for allowing us a vehicle, and to Cameo and the Realtors for being so easy to work with. So thank you to them. Like Assemblywoman Hadigi said, Michael Buckley is available on the phone, and this is really his subject matter expertise. He is the chair of the real property section, so he will be available to answer any technical questions that you may have. There is a memo uploaded on Nellis that details our portion of the bill section by section, and it's available to you all to follow along. I will go through the bill and just highlight each section, and if there's anything that pops out, please feel free to stop me, but otherwise I will just continue. So sections 2, 4, and 5 all provide the same corrective change. It's just extending the reference to all applicable areas of Chapter 116. Section 6 is providing a conforming change that mirrors what was brought in Assembly Bill 335 from 2019. It's an increased fee that is just conforming to what was changed in Assembly Bill 335. Section 7 is revising what is referenced as a certificate of resale to read a resale package. Over the years, Chapter 116 has been amended to refer to a resale package, and it's reflective of modern practice, so we're just updating that language. Section 8, it's adding new language that exists in Chapter 107 concerning non-judicial foreclosures and trustee sales, and adding that language to Chapter 21 as it relates to notification requirements and who must be notified in the cases of sale. The intent here is just to ensure that the proper people who are entitled to be notified in an execution sale are being notified in this instance. Section 9, subsections 1 through 5 are providing minor changes for clarity's sake to read a little better. And subsection 6 is providing in the case of judicial foreclosure, when multiple properties are owned, the judgment debtor would not have authority to direct the order on which those properties are sold. This is another conforming change that was made in a previous legislative session. The reference to non-judicial sales was removed, so we are doing the same for judicial sales here. Section 10 relates to abstract of title. I believe that this is a statute that hasn't been revised since 1911, so it was in need of a little updating. It deals with partition actions, so essentially if 2 or more people own a property and can't agree, this is the process it defaults to. And it's a lot of noise for not a lot of change. It's revising abstract of title to instead reference what's called a guarantee, which is again a modern practice, but it's not reflected in statute. And that change is carried forward through Section 11 as well. Section 12 is a minor change. It's just extending reference to include the additional articles of Uniform Commercial Code as well as the original articles. Section 13 is cleanup language. Again, it's deleting 2 references to personal property or crops recorded prior to 1935. The logic behind this is in 1965, the Uniform Commercial Code was adopted, and it governs all personal property, including agricultural liens. So it's duplicative, and we're removing the reference just to clean it up and modernize it. Section 14 carries forward that same change and revises some of the language to create parity between other areas of NRS. Section 15, again, a small corrective change. It's revising a plural to a singular for clarity's sake. Section 16 is, there was a bill in 2019 clarifying that a person can waive the benefit of protection for a landlord of real property. There's 2 dates in statute currently that state when notice must be given to applicable parties. So we are clarifying here that that date of notice can be whichever is later. And Section 17 is effective date.
And if we could, at this time, Chair, take it to our last co-presenter, Mr. Michael Buckley, and he will also be here to answer Q&A. And then I would, prior to taking questions, just like to walk the committee through an amendment I submitted yesterday. Mr. Buckley?
Madam Chair and members of the committee, I actually have nothing to add to what Maggie just said, but I'm available for any questions if you have them.
Okay, thank you, Mr. Buckley. Chair, I did submit a friendly amendment yesterday. I would like to walk the committee through it. It's just making 4 minor changes. The first change is to page 9, line 29, section 5.5, sub 202. It's changing the must to a may. It used to read must not exceed $350 for the transfer fee, and then the language we were adding in, beginning on January 1st, 2022, the monetary amount in this paragraph must be adjusted for each calendar year. I'm changing that must to a may, just to allow them the flexibility, only to increase it if they need to. So the must to a may. And then the next 2 changes are exactly the same. We are changing from section 5.5 sub 6A and section 7.2 sub 8. We're changing the word enumerated to required so that it reads not required in paragraph or not required in this section, and formally read not enumerated. One of the other changes as well is just to make the paragraphs uniform. We're changing the word charge to impose in section 7.2 as well. And the last change is just making section 7.2 sub 4B effective upon passage and approval. And you should have that amendment for you on that list, so just some word changes. With that, Chair, we are ready for questions.
Thank you so much. Are there questions from members of the committee? Senator Settlemyre.
Thank you, Madam Chair. I was just kind of curious. I was trying to find Ms. McGee's amendment online. I'm having a little bit of a difficult time, so.
They submitted a memo, not an amendment.
Okay. I'll have to look for that then.
Senator Settlemyre, through you, Chair Scheibel, you should have received that in your inbox as well. I sent it as well.
And I am following up right now. I do remember seeing both of these. It looks like the amendment is online. I'm not sure where the memo is. I apologize. Perfect. Senator Settlemyre has it in his hand. If our committee's manager is watching and she could perhaps upload it to Nellis, I'd be very, very appreciative. And in the meantime, are there any other questions from members of the committee? All right, I don't see any. So we will move on to testimony in support of AB 237. It looks like we might have, do we have anybody present to give support testimony? All right, no one present, so we'll go directly to the phones.
Thank you, Chair Scheibel. To testify in support on Assembly Bill 237, please press star 9 now to take your place in the queue. Once again, to testify in support on Assembly Bill 237, please press star 9 now to take your place in the queue. And Chair Scheibel, at this time, there are no callers to provide support testimony.
Thank you. We will move to testimony in opposition of AB 237.
Thank you, Chair. To testify in opposition on Assembly Bill 237, please press star 9 now to take your place in the queue. Once again, to testify in opposition on Assembly Bill 237, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to provide opposition testimony.
All right, is there anybody present to give neutral testimony? Not seeing any, we will move to neutral testimony on the phone on AB 237.
Thank you, Chair. To testify in neutral on Assembly Bill 237, please press star 9 now to take your place in the queue. Once again, to testify in neutral standing on Assembly Bill 237, please press star 9 now to take your place in the queue. Caller with the last 3 digits 000, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon. Sharat Chandra, SHARATH Administrator for the Real Estate Division. Good afternoon, Madam Chair, members of the committee. Sharat Chandra, Administrator for the Real Estate Division. Just wanted to thank Assemblywoman Hardegee for the bill. We just had a few questions, and I think and we reached out to the Assemblywoman yesterday. Just the drafting of the bill, we just had some more technical questions on the authorities that are being indicated in Section 1 and a couple of the other sections. But we will work through the Assemblywoman and get some questions answered, but just wanted to go on the record and say we're neutral on this. Thank you.
Thank you, caller. And with that, Chair, there are no more callers to provide neutral testimony at this time.
All right, thank you. We will close the hearing on AB 237. We will open the hearing on AB 398.
Good afternoon, Chair and members. Once again, I am Assemblywoman Sandra Hardegee, representing Assembly District 41, and now I am here to present Assembly Bill 398. I will keep my remarks very short and then hand it over to my co-presenters. Having spent 14 years, almost 15 years now in housing and the real estate industry, I'm happy to be here and help the industry with issues that impact us and help be a voice for the industry here at the legislature. Earlier this year, it was brought to our attention that there were some areas in the NRS that could use cleanup to help clarify issues regarding the SRPD, or the seller's real property disclosure. At this time, I would like to turn it over to Rocky Finseth and then to CEO Teresa McKee of the Nevada Realtors and President of the Nevada Realtors, Brian Spires. Mr. Finseth?
Chair Scheibel and members of the Judiciary Committee, once again, my name's Rocky Finseth, ROCKY-FINSETH with Career Nevada, here today representing the Nevada Realtors. It's a pleasure to join you in person today. First, let me take this opportunity again to thank Assemblywoman Hardegee for bringing this bill forward on our behalf. Chair Scheibel, in the interest of time, I would prefer to introduce Teresa McKee and Brad Spires, who will walk you through the bill, and then we're happy to take questions afterwards. Teresa?
Thank you. Thank you. Good afternoon, Chair Scheibel, members of the committee, and thank you for allowing me to speak with you today. My name is Teresa McKee, Teresa McKee, and I'm CEO of Nevada Realtors. Thank you also to Assemblywoman Hardegee for bringing this important piece of legislation forward. Before I walk you through the statutory changes in the bill, I wanted to give you a little background on what the SRPD is and who fills it out and when. And then Mr. Spires will follow up with how it's used in practice. But under existing law, the seller has the duty to complete and give the buyer the SRPD, the seller's real property disclosure, at least 10 days before the property is conveyed to the purchaser. This form is really important to ensure that the buyer is aware of exactly what the seller knows about their own property. It contains a comprehensive list of items that may be considered either defects in the property or things that have been fixed that the new buyer should be aware of. Most buyer's agents in their offers and in the contract ask the seller to provide this earlier than the 10 days before conveyance so that they can provide and conduct different inspections to find out what's really wrong and if it does affect the value of the property in their eyes. It's been a long-standing and clear understanding in the real estate community that the agent never fills out the SRPD on behalf of their client. This is to show what the client knows about the property. Agents have their own duty of disclosure, which is found in 645.252A1. They have to disclose all material and relevant facts that they know or should have known relating to a property. So there's two different duties here. The seller's duty is under NRS 113, and that's the duty to disclose on SRPD everything they know about the property. And the agent has his own duty under NRS 645 to disclose material and relevant facts. The reason this bill is before you, as Assemblywoman Howdy said, is that there are a growing number of lawsuits that name the licensees as defendants for a seller's failure to disclose on the SRPD. And the language in this bill seeks to limit those lawsuits aimed at licensees, at those agents, when the agent really isn't aware and has no way to be aware of what the seller knows and fails to disclose. So moving to the bill, Section 1 of the bill is line 9 and 10. It explicitly states that the seller's agent shall not complete the disclosure form on behalf of the seller. It's very important that this be the seller's disclosure. An agent can help explain things to the seller, but the seller is the one that has to put down what their knowledge is. In lines 29 through 37, that provides that the seller's agent is not liable if the seller is aware of a defect and fails to disclose that, or the seller becomes aware of a defect or it worsens before the conveyance. Finally, lines 38 to 41 state that the seller's agent must comply with his duty or her duty under NRS 645-252. And that duty, again, is to disclose to each party to the real estate transaction any material or relevant facts that they know or should have known relating to the property. Once again, on behalf of the association, we'd like to thank Assemblywoman Howdy for bringing this legislation on the association's behalf. And thank you, Chair Scheibel and members of the committee for allowing us to present on AB 398 this afternoon. And I'd now like to turn it over to Mr. Brad Spires, the president of Nevada Realtors, for a little bit of information on how this is done in the practice by the practitioners.
Thanks, Teresa. Brad Spires, for the record, S-P-I-R-E-S, Chair Seibel and committee members. Been practicing as a realtor in Nevada for over 30 years now. And I can't thank you enough, Assemblywoman Howdy, for bringing forward this legislation, which really codifies what we're doing already. You know, our clients look to us as their trusted advisors, and generally the most impactful investment that they'll ever make in their lifetime. And when we present the disclosures to a seller to complete, we make it clear that they must complete to the best of their knowledge without our input. We may not complete the form for them. As a realtor, we won't have previous knowledge about the house and some of these houses that have been occupied by the current seller for decades. So we encourage them to fill out the form thoroughly and honestly. And then the form is provided to the buyer, who then starts making some decisions based on it. That allows them to take further investigations into any of the items that may have been identified. And it really provides a critical step in the buyer's due diligence period. Now, the real importance of the bill is reflected in the increased number of realtors being named in lawsuits regarding a seller's lack of disclosure. While the realtor has nothing to do with the form completion, they're forced to use their insurance to defend themselves for an action that they had nothing to do with. So I think it's important, as Ms. McKee stated, that this does not relieve us of our responsibilities under NRS 645.252, which is the standard practice that requires us to disclose anything that we knew or should have known as a disclosure. So be happy to answer any questions, Madam Chair.
Thank you, Chair. We are now open to questions.
All right. Are there questions from members of the committee? Senator Pickard.
Thank you, Madam Chair, and thank you all for your presentation. I did more of these SRDPs as executive at a home builder than I did as a broker, because I did mostly commercial work. But I don't disagree with the idea here, but as Mr. Spires, you suggested, agents generally are not to be filling these out. These are to be filled out and signed by the owner. The agent makes no representation, and the broker makes no representation as to the condition of a property. At least in my experience, they were never intended to, as far as I could tell. And so I'm intrigued by the thought that this bill has anything to do with their being named in lawsuits. We can name, and I can approach this now being a lawyer who, at least I'm a recovering property lawyer. I don't do them anymore. But I mean, it's theoretically possible to name anyone in a lawsuit, whether or not they legitimately have any culpability or liability to the damages that are being sued over. So can you tell me a little bit about how this interacts with those existing lawsuits? Because this doesn't put them on the hook. It doesn't take them off the hook. That would be a proper motion for summary judgment to exclude them or remove them from the lawsuit. So can you help me understand how this interacts with, because we have a general custom here that we don't work legislation that will affect active litigation as a general rule, at least not without making it a deliberate action on our part. So can you tell me how this interacts? I want to get comfortable to make sure that we're not upsetting some other things.
Yes, Chair Scheibel to Senator. This is more of an answer not for the practitioner, but for our attorneys. So Ms. McKee, our legal counsel and CEO, will respond.
Thank you. Chair Scheibel, through you to Senator Pickard. Of course, it would not affect any current outstanding lawsuits that are being filed. This was our attempt, and in working with the Trial Lawyers Association as well, to try to make it more apparent that the agent cannot, should not, shall not, and will not fill out the SRPD. Anything that we could do to make that more clear, you know, I think we tried in the past even to handle this a different way, but what NRS 113-130 currently says is the seller shall complete the disclosure form, and then number 2, the seller or the seller's agent shall serve the purchaser or the purchaser's agent with the completed form. Again, I'm kind of in the dark as you are as why somebody would infer that that is a duty on the agent to fill out the form. But that is what's happening. There are cases out there where the agent is being held liable for failure to disclose under 113, where there is no duty. And so this is the attempt to make it ultimately and virtually clear that the seller's agent shall not complete the disclosure form. All of the seller's duties, all of the seller's agent's duties are under 645. 113 is reserved for the seller themselves and their liability for non-disclosure, and anything we can do to keep the seller's agent within 645 and the bounds of their duties and the punishments that go with 645 violations, those stay with the seller's agent, and 113 stays with the seller.
Right, and thank you for that. I think I agree. I wonder if we really need to add the language in section 1A sub 2, because I think that's already established. But I think one of the things that I would think we would want to look at, or I would suggest you might consider, is removing the requirement for disclosure under NRS 625. Because I think there is the hook that plaintiff's counsel is probably looking at, in that if the agent has any duty to disclose anything and that is not disclosed, that's what they're going to rely on to hook them in. I don't know, I've not seen the lawsuits, but that's an immediate discrepancy that I think we might be able to resolve. In any event, I like the idea. I'm supportive of the concept. Just want to get it right out of the gates. Thank you, Madam Chair.
All right, any other questions? Seeing none, we will move on to testimony in support of AB 398.
Thank you, Chair Scheibel. To testify in support on
Sorry,
Assembly Bill
Mr. Kyle.
390.
It looks like
No problem at all.
we have somebody in person to testify?
Thank you, Chair and members of the committee. For the record, David Daslich, Director of Government Affairs with the Vegas Chamber. We were in support of this legislation on the Assembly side as well, on behalf of our Realtor members and many members who buy homes and other real estate. We do think this provides good legal clarification and protections for buyers and sellers alike. We're in support and would urge your support as well. Thank you.
Thank you so much. Anybody else in person? All right. We will then move to testimony on the phone in support of AB 398.
Thank you, Chair Scheibel. To testify in support on Assembly Bill 398, please press star 9 now to take your place in the queue. Once again, to testify in support on Assembly Bill 398, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to provide support testimony.
All right, then we will move to testimony in opposition. I don't see anybody present, so we will take opposition testimony on the phone on AB 398.
Thank you, Chair Scheibel. To testify in opposition on, to testify in opposition on Assembly Bill 398, please press star 9 now to take your place in the queue. Once again, to testify in opposition on AB 398, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to provide opposition testimony.
Okay, then we will move to testimony in neutral. Again, not seeing anybody in person, so we'll go straight to the phone lines, please.
Thank you, Chair. To testify in neutral on AB 398, please press star 9 now to take your place in the queue. Once again, to testify in neutral on Assembly Bill 398, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to provide neutral testimony.
All right, thank you for your help, Mr. Kyle. Thank you, Assemblywoman Howdegi, for presenting to us today, and to all of your co-presenters. We appreciate your time with us, and I will now close the hearing on AB 398. I will move to the hearing on AB 342. I understand we have Mr. DeRico, and I hope I pronounced that right, and you'll correct me if I'm wrong, but I believe we have him on Zoom. I will now open the hearing on AB 342.
All right, thank you so much, Chair Scheibel. Good afternoon to everyone and all the members of the Senate Judiciary Committee. My name is Chris DeRico, and I am Chairman of the Board of Parole Commissioners. Before I start, I would like to thank Senator Spearman and all the members of the Sunset Subcommittee for assisting us with this proposed legislation, and I appreciate the opportunity to provide you with an overview of AB 342. In its present form, Section 1 of this bill, specifically subsection 6, which refers to NRS 213.10885, requires the Parole Board to comprehensively review the standards adopted by the Board on or before January 1 of each odd-numbered year. The Board has used a validated risk instrument since 2003. The parole risk instrument was created based on the recidivism measure of a new felony conviction within 3 years of release from incarceration. In order to properly assess the adopted standards that are in place, at least 3 years of data review is necessary. The Board contracts with an outside consultant, who is JFA Associates, to perform the revalidation of these standards. This process requires the consultant to review at least 3 years of data, perform the assessment, analyze the results, and prepare a report with a recommendation to the Board. The Board then needs time to review the consultant's recommendations and either adopt and/or modify the standards and approve them at a Board meeting. Once approved, the Board must then work with the Department of Corrections to make the appropriate changes to the approved revalidated instrument in the Nevada Offender Tracking Information System, which is called NOTICE. Then it can be implemented. This process can take anywhere from 4 to 5 years, and the cost to perform this revalidation has ranged anywhere from $20,000 to $25,000. The requested amended language in Section 1 is to change subsection 6 to remove the following: on or before January 1 of each odd-numbered year, and replace it with at least every 5 years. Moving on to Section 2 of this bill, according to statute that is in place now, the parole board shall establish a program of lifetime supervision of sex offenders to commence after any period of probation or any term of imprisonment and any period of release on parole. Under current law, the parole board sets the conditions of lifetime supervision for qualifying sex offenders. These hearings generally occur about 90 days before an individual is about to complete their sentence for the underlying offense. This means that these conditions of lifetime supervision may not be imposed for 1, 2, 5, or even 10 or more years after the individual is sentenced. Additionally, after the parole board sets these conditions, this is generally the last interaction the board has with these particular cases, unless there is a request to modify a condition of lifetime supervision. According to subsection 7, a sex offender who commits a violation of a condition imposed pursuant to the program of lifetime supervision is guilty of a Category B felony. There is no violation hearing, much like you would see for a parole or probation violation. Violations of lifetime supervision are considered a new crime and are ruled upon by a district court judge, not the parole board. So here is the way lifetime supervision conditions are imposed and how we can make it better moving forward. So I want to provide a little bit of an explanation. When a district court judge imposes a sentence of probation on an individual and they later allegedly violate those conditions of probation, the probation violations are heard back before the district court judge who imposed the probation. It works the same way for parole. The parole board sets a condition of release, and later, if there are alleged violations of parole, those violations are heard back before the parole board who set those conditions. However, the way things stand now for lifetime supervision of sex offenders, the court imposes the term, meaning lifetime supervision for that crime, but it does not impose the conditions of that lifetime supervision at the same time. Rather, the parole board imposes the conditions of release approximately 90 days prior to completing their underlying sentence. If a person violates these conditions, it is a new criminal offense and the determination is made by a district court judge. So essentially, as we stand now, the parole board sets conditions on qualifying cases where we have no further dealings with regard to future violations. The court makes the determination. The proposed language in Section 3 is to have these conditions imposed at the sentencing hearing and were modeled after the United States court system. They do just this. The federal court will sentence someone for an underlying sex offense and put on record at this same sentencing hearing that upon completion of the underlying sentence, that the individual will be on a term of lifetime supervision with the following conditions to follow the underlying term. In my opinion, this just streamlines everything. So one important aspect of how this bill is worded, the parole board will continue to set these conditions for anyone sentenced prior to July 1 of 2021. This means that we're going to still be doing this for years to come. However, we did not want the district courts to have to add any additional hearings in order to set these conditions. The way this bill is written, we will continue to handle any case that was sentenced prior to July 1, 2021 and impose these conditions. In Section 3, it is all the new language. It should essentially mirror Section 2, which is the current language, and that way we have continuity. The last thing I wanted to mention here is I've reviewed the Nevada District Attorneys Association proposed amendment that was filed today, and the changes appear appropriate. However, I'd like to make just 2 comments regarding their submission. In Section 3, subsection 9, they are requesting to remove language. I would suggest that if this occurs, that the same language be removed in Section 2 of the bill in Section 9 so that they mirror each other. In essence, the request is that the language either be included in both sections or removed from both sections for continuity. Also, I did see where the Nevada District Attorneys Association requested that the original language in Section 2, subsection 14 be placed back into the bill. However, this appears to have been missed for Section 3 as it was not added there. I believe this just may have been an oversight. As such, once again, I would request that if this language is added back into Section 2, it should also be added back into Section 3 as well, so that the two statutes mirror each other. And with that, I'll conclude my presentation for today, and I'm happy to answer any questions that any of you may have.
Thank you so much. My first question is, did I pronounce that right, Mr. DeRico?
Chris DeRico, for the record, you nailed it.
Awesome. Do members of the committee have any questions for Mr. DeRico? I don't see any questions from members of the committee, so I have just a couple. I wanted to clarify something that you said that maybe I misunderstood. Did you say that sometimes lifetime supervision is imposed at a date later than the sentencing?
Chris DeRico, for the record. So the court will impose a term of lifetime supervision at the sentencing hearing. They'll impose it there, but what won't happen is the terms or the conditions of that lifetime supervision term aren't imposed there. So that's the clarification. It is imposed at the sentencing.
Okay, and so this bill would include the terms of the lifetime supervision at the time of sentencing, as opposed to that follow-up hearing.
Yes, Chris DeRico, for the record, absolutely. One-stop shop, add a couple minutes to the sentencing hearing and have everything included all in one. And the best thing about this, in my opinion, is you'll have the judge present, you'll have the district attorney present, you'll have the public defenders, retained counsel present, the defendant present, the pre-sentence investigation. Everything is fresh at that point in time.
Yes, and I agree. That makes complete sense to me. I think I just misheard what you said, and so I was a little bit confused. And along the same lines, then, I understand both from your testimony and from my practice that a violation of a condition of lifetime supervision is itself a criminal act, and so those are charged as violations of lifetime supervision. And you're not suggesting that we make any change in that statutory scheme, right?
Chris DeRico, for the record, I am not recommending any change there. That is already in the statute that any violation of lifetime supervision is a new crime, and not recommending any changes there at all.
Fantastic. And I just wanted to ask you if you'd had a chance to review the amendment proposed by the Nevada District Attorneys Association. It has been posted on Nellis, and I apologize. I'm just not sure if that was something that was provided to you, if you've had a chance to review it.
Chris DeRico, for the record. Thank you, Chair Scheibel. So I believe I did bring that up in a little bit, but I'll cover it a little bit more. I have had an opportunity to review it as well as speak with them yesterday, and they have added in certain sections back into the bill itself, or proposing that. And I think they're working together, and I've been working with them and also the public defenders as well. I think we could put it together and kind of craft and clean it up. But yes, I'm aware of the proposed amendment. I don't have any issues with it. I think it could work as written now or with what they propose. The biggest key to this particular bill was just to have to streamline everything, to have these conditions imposed at the time of sentencing.
And that makes sense to me. I appreciate that. I think I have a couple other questions that I will take offline about how we address violations of lifetime supervision, but I don't want to get too far outside the scope of the bill. So are there other questions from members of the committee? Not seeing any. We will move then to testimony in support of AB 342. Doesn't look like anybody in person to give testimony, so we will go directly to the phones, please, Mr. Kyle.
Thank you, Chair Scheibel. To testify in support on Assembly Bill 342, please press *9 now to take your place in the queue. Once again, to testify in support on Assembly Bill 342, please press *9 now to take your place in the queue. Once again, if you've recently joined us, we are currently on support testimony for Assembly Bill 342. If you'd like to provide support testimony at this time, please press star 9 now to take your place in the queue. And Chair Scheibel, at this time, there are no callers to provide support testimony.
Okay, we will then move to testimony in opposition to AB 342. Again, not seeing anybody in person, so we will go to the phones.
Thank you, Chair. To testify in opposition on Assembly Bill 342, please press star 9 now to take your place in the queue. Once again, to testify in opposition on AB 342, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 389, please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Good afternoon, Chair Scheibel and members of the Senate Judiciary Committee. My name is Jennifer Noble, Jennifer, and I am testifying on behalf of the Nevada District Attorneys Association today. And in an abundance of caution, I am testifying in opposition, but I want to thank Chair DeRico for speaking with me yesterday and on another occasion and working with us on language for this bill. And it sounds like we're very close. Our proposed amendment, which is up on Nellis, first adds back the requirement that courts notify the central repository regarding any warrant for arrest issued for violation of lifetime conditions. That's in Section 2, Sub 14 of the bill. Second, our amendment takes the finding of extraordinary circumstances that might warrant a departure from required conditions of lifetime supervision out of the adversarial setting of a district court sentencing and keeps it, or the attempt is to keep it with the parole board. And that's where I think perhaps Chair DeRico and the NDAA are just a little bit further apart. We would like the offender to be able to go back to the parole board for adjustment of those conditions, or somebody if that's needed, but we'd like to keep it out of a post-conviction context because we don't want to have public defenders and DAs litigating these special conditions long after the offender is released. And so we would actually want to keep Section 2, Sub 9 in, or work on language that at least modifies it so that they would be able to approach the parole board regarding those conditions. Finally, our amendment tries to clarify that when a sex offender resides outside the state of Nevada and they want to be evaluated for release from lifetime supervision, they don't have to return to the state, which I think is the goal of the original bill or of the current bill language, and they can be evaluated by a qualified person in their jurisdiction of residence. In other words, someone who has similar qualifications to the qualifications outlined in NRS 176.133. Those are specific requirements for people who evaluate sex offenders. So that's really the substance of our amendment. But we would like to thank Senator Spearman and Chair DeRico for continuing to work with us and stakeholders on language that addresses our concerns. And that concludes my testimony. Thank you.
Thank you, caller. Caller with the last 3 digits, 318. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Good afternoon, Chair Scheibel and members of the Senate Judiciary. This is Kendra Birchie, Kendra Bertschy with the Washoe County Public Defender's Office. Today I'm testifying on behalf of my office as well as the Clark County Public Defender's Office for our opposition. We first want to thank Chair DeRico for speaking with us on several occasions to try to ensure that we understand the intent of this bill. We appreciate his attempts to streamline the process. As currently written, we are confused, or we are still concerned that it will actually confuse issues and make it more complicated for our clients. I apologize, I'm not sure whether the NDAA amendment has been completely adopted or not. So I'll just start with, we have no issues with the change in Section 1 of the bill and would support that section. For Section 2, we are concerned, as the District Attorneys Association mentioned, regarding regarding some of the subsections in order to allow it to be heard before the court at sentencing. We don't think that is a problem, is appropriate. However, we are just concerned with the additional time that it's going to take, as well as if our clients are modifying those conditions later through the court or if it's done through the parole board. So we would actually agree with the district attorney's office that section 3, subsection 9 should allow for that to be done by the parole board instead of having to return to court to address conditions. We disagree with the proposed amendment from the district attorney's office regarding the warrants going into the central repository. It's our understanding from speaking with Chair DeRico that it was the courts who had requested that to be deleted, and we would agree with that. We also look forward to continuing to work with Chair DeRico just regarding some of the language for requesting for the person to be removed from lifetime supervision. As written, it will require our office to participate in this and to do the documentation. And at this point, it would have a fiscal impact. So we are working with him to remove the fiscal concerns and to ensure that this language does fit his intent. And we appreciate him bringing forward this bill. Thank you.
Thank you, caller. Caller with the last 3 digits, 080. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Hi, Jim Hoffman representing Nevada Attorneys for Criminal Justice. In the interest of brevity, I would just echo all of the concerns that Ms. Birchie raised and note that we are also amenable to continuing to work with the bill's proponents. Thank you.
Thank you, caller. And with that, Chair Scheibel, there are no more callers to provide opposition testimony at this time.
Okay, we will move to testimony in neutral on AB 342. There is nobody present in the committee room to give testimony, so we will go to testimony on the phone, please.
Thank you, Chair. Excuse me again. To testify in neutral standing on Assembly Bill 342, please press star 9 now to take your place in the queue. Once again, to testify in neutral on Assembly Bill 342, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to provide neutral testimony.
Okay, thank you. I will now close the hearing on AB 342. That takes us to our last bill on the agenda today, which is AB 17. I understand our presenters are present by Zoom. I am expecting a Victoria Gonzalez, Tom Larson, or perhaps Lawson, and perhaps an Aaron Evans. All right, I see Victoria Gonzalez, I see Tom Larson, aka Lawson, who will clarify that for us, and whoever wants to go first may go ahead. The hearing is now open.
Thank you. This is Tom Lawson. I'm the Chief of the Department of Public Safety's Parole and Probation Division, and I'll be presenting Assembly Bill 17 for you today. Thank you, Chairwoman Scheibel and the members of the committee for hearing this bill. I have a presentation that I'm going to share. And did the presentation come up on your screen?
Oh, sorry. Yes, we can see it, but it looks like we can also still see the program that you're using. It's not in presentation mode. We can see the slides and all of the icons, which is fine. Perfectly fine to continue that way.
Get rid of everything else. Is that better or worse?
That is exactly the same.
Blown up. Oh. All right.
All right, that is fine.
Okay. Under existing law, the division is required to make a recommendation for either an honorable or a dishonorable discharge to the sentencing district court upon the completion of a term of probation supervision. For parolees, the division has the authority under statute to issue an honorable or dishonorable discharge upon expiration of the parole supervision term. Historically, there was a distinction between offender receiving an honorable versus a dishonorable discharge. That distinction being related to the restoration of an individual's civil rights upon that discharge. With modifications to statute during the 79th and 80th legislative sessions, there is no longer a distinction between the rights returned to an individual following an honorable versus a dishonorable discharge. So under NRS 176A.850, the court is responsible for issuing an honorable or dishonorable discharge upon the recommendation of the division, and the qualifiers for each are defined in there. The requested change is to remove the reference to the court's order for the honorable or dishonorable, and to simply issue a discharge in the general term. Under NRS 213.154, the change would remove that language from the parole references, and again, just issue a discharge. Then the third primary statute we're looking to change with this bill would be NRS 213.155, and this relates to the division's requirement to provide the supervised offender with a document detailing the restoration of their civil rights upon discharge, and as currently the classification of their discharge. The recommended changes, again, to simply remove the honorable versus dishonorable distinction between them. The benefits of this change are that continued classification of honorable versus dishonorable discharge could be misleading to prosecutors in the court for future prosecutory decisions or sentencing decisions. There are offenders who are relatively compliant that, due to the wording of the statute, receive dishonorable discharges. And there are also offenders who are relatively uncompliant with the wording of the statute that qualify for an honorable discharge. And so that one-word distinction is not really an accurate representation of the offender's performance during supervision. And we believe that there are ways that the division may ensure that the courts and the prosecutors have the information they need to make their informed decision regarding future eligibility for deferral programs and sentencing and prosecution decisions or sentencing decisions without that one-word distinction. At times there are delays in the resolution of probation cases due to that one-word distinction. There are times when the judge does not agree with the recommendation of the division, which ends up delaying the signing of the discharge. It increases the number of hearings for resolution of those disagreements. There are cases where the person has expired from supervision and the court has just simply elected not to sign the discharge in either form or issue an order on that. And that kind of places the person in a status of limbo. The division no longer has the authority to exercise control over that person under their conditions of supervision because their period of probation has expired. However, we cannot issue the discharge document because the court has not ordered a discharge in either direction. And so not having that may impact the offender's restoration of rights, because the restoration of rights is now upon discharge. And if they haven't received their discharge, then the argument is made, do they have their civil rights restored even though they are outside the sentence window and are no longer under supervision? In the current environment of criminal justice reform, it is incumbent upon the state to examine all processes that may create obstacles and barriers to continued rehabilitation and access to assistance. The assertion of an honorable or dishonorable discharge is one such possible obstacle, and the elimination of that requirement allows for an individual to be assessed on the merits of their factual compliance during supervision and not merely on their previous criminal record or potentially erroneous and misleading information in their supervision history. For example, if you have a person who's on supervision at the very beginning of it, they're not adapting very well to their period of supervision, and they have some violations and they're not paying their fees. However, with some support and wraparound services, they're able to find a steady job, find a steady residence option, get engaged in counseling, and they turn their supervision around, well, the overall totality of the circumstances of their performance during the supervision term, the entire supervision term, should be the basis upon which their success during that supervision term should be measured. Again, if they have early problems based upon the wording in the statute, that could result in their overall supervision term being deemed dishonorable when their more recent performance should be the weighed factor. I also want to note that the changes impacted, or the changes we're requesting here, do not alter any of the language regarding early discharge of offenders from probation under AB 236 of the previous session. In fact, the early discharge elements of AB 236 do not distinguish between an honorable or dishonorable discharge type. It just merely refers to the discharge as a whole. There was a friendly amendment submitted by Victoria Gonzalez and the Nevada Department of Sentencing Policy. That amendment was adopted and is reflected in reprint 1, which is before the committee today. So I won't cover that since it's already been adopted. That change just makes conforming changes to the area underneath their purview regarding reporting of statistics in their annual report to the legislature. And again, just removes the reference to honorable or dishonorable from that report. Now, the division has engaged in discussions with the ACLU and representatives of the Clark and Washoe County District, Public Defender's offices. We've also spoken to representatives of the Clark and Washoe County District Attorney's offices. My staff has been in touch with a couple of the district court judges regarding concerns that they've had with this. On the assembly side, the district attorney's offices testified in opposition to the bill, and we've had conversations with them in the past and are open to having additional conversations to try to resolve those concerns. And primarily from the court side, the concerns that were related to us is that if there was a person who is currently involved in a diversion program, and the terms of that diversion program said that if you receive an honorable discharge, then your sentence will be reduced or your charge will be amended to X. If you receive a dishonorable discharge, then Y is the final outcome of your case. I can see the court's, issue with not having that honorable versus dishonorable word to rely upon, but the thought process is the court is the one who decides whether the discharge will be honorable or dishonorable in the first place. And so in regards to those individual cases where the diversion program is expecting an honorable or dishonorable distinction, in their order of discharge, the court can merely say that based upon the totality of circumstances, this would be deemed an honorable or dishonorable discharge for the purpose of this existing deferral program. And so I don't think that should be a hurdle or a barrier to consideration and passage of this, because there are certainly ways to accommodate that distinction for those cases that are already in that deferral status. And again, since the court is the ultimate decider of whether a probation term is an honorable or versus dishonorable discharge themselves, then they can look at the totality of the circumstances that is documented in the discharge report. And again, those factors are already documented in the discharge report. So the division would provide the same information as providing now. We're open to having discussions with the stakeholders to ensure that if there are any elements from that discharge report that are missing, content that is missing and needed for those decision makers to work through and decide the success of that offender's probation term, and we are more than welcome those discussions, more than willing to adapt that report to meet the stakeholders' needs for that. It was even thrown out in our conversations with the DA's group of perhaps that could be, those elements could be codified in the statute. We want that information to be available to them. Another element that we talked about and offered in our discussions with the DA's group is that our new records management system and the court system for Clark, Washoe, and I believe also Douglas are all carried by the same vendor. And so it'd be very simple for those courts in particular to have a link, and the DA's offices to have a link into our system as a read-only level, so that those discharge reports are readily available at will for prosecutorial decision-making. For the courts and DA's offices that aren't within Odyssey, part of our RFP included outside access for stakeholders to provide that same access. So the division is willing to and wants to work and find a workable solution to ensure that all the prosecuting offices and the courts have the best information available to make a determination as to whether the offender's probation completion was successful. But we don't believe that the one-word header of honorable or dishonorable on the top of that discharge document should be the deciding factor. The facts and circumstances of their performance during supervision is the key element here. And with that, I would be happy to answer any questions from the committee.
All right. Thank you, Chief Lawson. I think we have a couple of questions. I will start with Majority Leader Cannizzaro.
Thank you, Chair Scheibel. So I guess as I am understanding this, there's a concern about being able to place people into categories of either an honorable or dishonorable discharge. And from your perspective, that becomes problematic because maybe they don't fall directly into honorable or dishonorable. Am I understanding that general, I guess, concern from the division?
Tom Lawson for the record. I'm struggling. I'm trying to find a way to stop sharing. I'm not finding it while I'm looking.
Well, we don't see it on this end, so.
Okay.
Yeah.
Good. Okay.
We see you.
I think Broadcast Services did me a solid on that one. Okay, so Tom Lawson for the record. Yeah, the concern is that with the elimination of the distinction of and restoration of civil rights, that the need for that one-word distinction no longer exists. Where before, if you received an honorable, you got your rights back under certain circumstances. If you received a dishonorable, you didn't. And that changed over the past two sessions. And so now that one-word distinction has the potential of misclassifying somebody's overall performance based upon the way the recommendation is defined within the existing statutes. And so what we're saying is we lay out the facts and circumstances of the offender's supervision instance to the court in the discharge document. That's not going to change. We're still going to lay out the same facts and circumstances we do now. It's just we're asking for the ability to not title that document honorable or dishonorable, and because honestly that is misleading at times, and that the facts and the circumstances of that person's supervision instance should be the determining factor for their success and not that one word recommendation by the division.
And I guess that's I feel like there may be, can you hear me okay?
I can now.
Okay.
Thank you.
I think we had a little bit of a power shortage, and my mic went out as well as some of the lights here, but I think we're back in business. And I think that you have sort of illustrated two things. One, that sometimes it appears that it may be difficult to classify someone as either honorable or dishonorable. And then two, because there is no distinction between the civil rights restoration between the two types of discharge, that there is an issue. I think that the civil rights piece makes sense irrespective of the different sets of discharge. And I understand that it may be difficult, and I guess you can elucidate why that is the case for someone to either receive an honorable or dishonorable, because in practice, folks who are on probation or on parole who are not compliant can be reinstated, right, absent certain circumstances. Generally, at least with probation, that's up to the court to be reinstated on probation, even if they're not compliant with the conditions of their probation. And oftentimes that will take the form of potentially the imposition of additional requirements. And at the end, if that sort of helps to get the person back on track, can still be given an honorable discharge, despite the fact that there may have been some bumps along the way. And so I guess what I am struggling with is there is a very, at least in my mind, a distinction between someone in that kind of category, or someone who, frankly, is put on probation and complies with all the terms of their probation, versus someone who absconds for a period of time, who commits additional offenses, and yet is maybe not arrested on those offenses, or otherwise continually violates the conditions of their probation, and is not compliant. And in this bill, it seems that once that probation period is run, they are simply discharged without question, if I'm understanding this correctly.
Tom Lawson, for the record. I guess in that situation, they're going to be discharged no matter what. The sentencing term is defined. Under AB 236, those sentencing terms of the possibility of promotion were actually shortened. And so the time is going to elapse, and the person, unless they abscond, of course, if they abscond, that's a different animal, because the laws are very clear that when they're in absconder status, i.e. they've been, we'll say, in the wind, no better way to describe it, for more than 60 days, once that happens, then their time freezes until they're caught and brought back before the court to decide whether they want to reinstate them back to supervision or to revoke them to complete their sentence and incarcerated. So beyond the absconders, whether they're compliant or not, their term is going to expire at some point in time. It may be slower because they're not earning compliance credits for payment of fees, education programs, payment of restitution, those kind of things, but the time will keep ticking until they're no longer eligible for that. So the descriptor doesn't change the facts of the case. And so the fact that they were non-compliant, the fact that they failed to make their payments, the fact that they didn't pay restitution, all that will be in the discharge report as it is now. And so as a reviewer in your role as a reviewer, as a court's role as a reviewer of that, you're going to have it spelled out exactly what the offender did in terms of their supervision period. Their positives, their negatives. It's just not going to have the header on there saying that the division feels it should be an honorable or dishonorable, because the court is the finder of fact. The court will review the document and order the discharge. The court would order whether there were compliance with the terms of supervision to qualify for a deferral program. That's still the court's discretion, and you as the prosecutor would still have the discretion to take those facts and circumstances and I guess consider those to future charging decisions. There just isn't a debate about the header of the piece of paper that you're reading.
And I guess that's where I have a little bit of uneasiness, is that first, there's a very big difference if you're saying that somebody is coming before the court on an offense that is probationable, and either the state or the defense is arguing that someone is fit for supervision, right? Somebody who is amenable to the terms of probation, for example. If they have been on probation twice before, but there is an honorable discharge associated with both of them, that implies that that is someone who can abide by terms and conditions of probation and who can be supervised. Maybe they need some additional services, but that's somebody who is generally supervisable by the division. Whereas if somebody has two dishonorable discharges from two prior felonies or gross misdemeanors, then that is a very different circumstance for the court. And sometimes in those pre-sentence investigation reports, not all of those facts are delineated as to prior conduct on probation, except in cases where somebody has been revoked or somebody has been given a dishonorable discharge. So is the division going to ensure that the full details of every probation grant then are in every PSI? Because oftentimes what we see in those is where there's somebody who's been revoked or given a dishonorable discharge, you'll see why that is the case, but otherwise it is left without there aren't typically paragraphs that say, this person was compliant with this term, this term, this term, and this term of their probation. So in terms of giving the court the right evidence as to whether someone's supervisable, to me, the distinction between honorable and dishonorable is important and plays into the ultimate sentence that may be given to that offender.
Tom Lawson, for the record, in response to that, I can absolutely see that. That distinction in statute, it's easy for the PSI writer for a future instance to just refer to that blanket honorable or dishonorable to paint the picture. And I guess that's the point of this moving forward, is we hope we don't rely purely on that. We would list the facts and circumstances of that case. So the example that I've used in the past for somebody who earns a dishonorable, but probably shouldn't, is the case of somebody, let's say they have hundreds of $1,000s of restitution, but their term of probation is only 12 months. So if we look at how do we amortize that $100,000, just for a round number, over 12 months, then we look at what's the earning potential of this person while they're on supervision. Is it possible for this person to pay an average of over $8,000 a month towards their restitution? And more than likely not, the answer is no. And so that person will automatically qualify for a dishonorable discharge, even though they were compliant with every other term of their supervision, but because they couldn't pay their full restitution. And that's happened in the past. Now, there are provisions in there about unless the person can make demonstrate to the division that they're had an economic hardship. Well, that's not defined either. And so some courts will say, sorry, you didn't amortize that, and pay off the entire amount in sometimes an impossible manner, and order a dishonorable discharge because of that, when they were compliant with all of their terms. And so I agree with you that that practice will need to change, and that's what the division is offering here, and willing to even codify if we need to, of what needs to change in the discharge report to ensure that the courts and the prosecutors have the information to base their future decisions upon. And whether it's in the PSI, whether it's in the previous discharge report, or it's in both, those facts need to be available to the court and the prosecutor, and we are committed to ensuring that the court and prosecutors have that information for their future decisions.
And I guess you bring up I think a very common circumstance, which is folks who cannot fulfill their terms of restitution and often then are subject to a civil confession of judgment. But the current NRS provides for that economic hardship as verified by parole and probation, which I will say is commonly granted by the courts for folks who just can't make that full restitution, or where their probation term or parole term may be extended in order for them to pay that restitution. And so I think, if we were talking about a change to the law that allowed for those particular cases to not be automatically given a dishonorable discharge, that would make sense to me. But I think there are big distinctions between folks who are honorably discharged and dishonorably discharged, and it plays into future sentencing decisions. And I guess my one comment on that before I have another just sort of question and point here is that in the PSIs and in the discharge reports, they're often very pro forma. They don't include all of the details, and they don't include instances of honorable conduct. It's usually this is one of the reasons why this person was revoked, without much detail. So if we're talking about moving to wholesale discharge without further distinction, there would need to be a lot more information, I think, given to the courts as to the performance of someone who is being supervised by the division, both in those discharge orders and in the PSIs that are provided to the court, which I think, and we won't go down too much of a sort of rabbit hole here, but for gross misdemeanors, certainly when you're not relying on PSIs, because most gross misdemeanors, absent child abuse and some other delineated offenses, PSIs are not required. The other thing that you brought up was the idea of the diversion courts, and that the court would still have the ability to make those particular distinctions. And I guess the bill doesn't necessarily allow for that the way that I read it. It allows for simply a discharge. And most of the time when we're talking about something in a diversion court or performance of completion of drug court, veterans court, mental health court, is because there are negotiations that contemplate that in order to incentivize someone to stay with a program of treatment rather than, sort of throw it by the wayside or decide they don't want to participate in that. And so how do you envision that working where it is tied to a contractual agreement between the parties that if and upon someone's successful completion of a program of treatment, that because of all of the information that came out at sentencing was something that was deemed necessary by the court, that is what would trigger either a reduction or a dismissal of the charge.
Tom Lawson, for the record, I think the way you worded it is a very good way of distinguishing that. Successful completion of this program, the court's determination of successful completion of supervision. Again, the classification of that is and would remain up to the court of the judge would look at that and say, okay, I ordered you to X, Y, and Z. You performed in this manner. Does that meet my standard for X, Y, and Z? And if the judge were to review that and say, yes, it does, then they grant and approve the completion of the diversion contract. If they don't meet it to their standard, then they don't. I guess it's the same as really the same process as it would be now, because now the court deems it to have met the conditions by saying it's an honorable discharge and stamps it as such. If they don't meet the conditions, they call it a dishonorable discharge and they stamp it as such. So again, the facts will be laid out and it's up to the court to make that determination in the same manner it is now.
And I think for cases moving forward, I think some of this concerns me because I think it may lead to restricting those instances where that treatment may be beneficial to the offender, and if we can get treatment, there may be a reduction or a dismissal. I think this sort of takes away, if you will, that tool from the toolbox. And then I think additionally for those cases that are still pending, to the court's concern that you mentioned from the district courts, for those cases that are still pending, there are negotiations and plea agreements that have been signed that include that language, and how you kind of work around that in this new context, I think is difficult and may pose some issues. So maybe something to continue to discuss on that part. Thank you, Chair.
Thank you. Other questions? Senator Orangel.
Thank you very much, Chair Scheibel, and thank you, Captain Lawson, for presenting Assembly Bill 17. And this brings to mind a story an attorney I work with down in Las Vegas told me about a client who was on probation supervision and was ordered to an inpatient drug treatment program. And there was some kind of argument with one of the other people there getting treatment. And there was a fight, and they got kicked out of that inpatient drug treatment program. But they were consistently testing clean. And what I like about the bill, and correct me if I'm wrong, but I'm thinking here, whoever's reviewing that person's time on probation under supervision would be able to weigh both factors in. They might be able to not just have, a label that says honorable discharge or dishonorable discharge, but they might be able to say, oh, wow, this person tested clean for 12 months. Every urine test was clean. They got kicked out of this inpatient drug treatment program, but maybe they didn't get kicked out because they were using drugs, but maybe they got kicked out due to a personal issue with another person there who's getting treatment. So is that correct in how I'm interpreting AB 17, that more things like that would be able to be weighed and taken into account?
Tom Lawson, for the record, I guess on the parole side, since the division is the finder of fact whether somebody quote unquote meets dishonorable or honorable discharge at this time, yes, we do. We look at the totality of the circumstances, and I would think that the courts would do the same on the probation side. There are those positive and negative factors. Again, even if they were to test dirty at the very beginning of their programming, we expect there to be a period of adjustment. That's why we have graduated sanctions in place. That's why we have, steps to be taken. That's why there's a differentiation between technical violations and non-technical violations now, new offenses. So with the expectation that people are going to have an adjustment period, and if the supervision is appropriate and the wraparound services and the programming is proper, we should see some of those hiccups and speed bumps at the beginning of their term and then see those go away and have longer term success at the end. But yes, the totality of circumstances is what that overall determination of success should be. It shouldn't be one individual thing, unless of course you come right out of the gate and you commit another violent crime or something like that. Well then, rightfully so, you should be revoked for that, and then that would be the only classifying event for that period of supervision. But for those people that are adjusting and show progress and progression, the totality of the circumstances needs to be the weighing factor, not just that one isolated event.
Thank you very much, Captain Lawson. Thank you, Chair.
All right, I see Senator Settlemyre.
Thank you, Chair. I was just going to ask, what percentage of individuals are you currently at that are getting a dishonorable discharge versus an honorable one?
Tom Lawson, for the record, I don't have that at fingertip, but I can certainly get that put together and respond to the committee in writing with that, sir.
I appreciate that, and thank you, Madam Chair, because if this is such a big issue, I find it odd that he doesn't know the percentage or even a ballpark of how many are honorable or discharged. And I'm concerned with that because, frankly, I think that distinction is a question of accountability, because it seems to me from reading this, you're only dishonorable if you fail to meet the conditions, fail to pay restitution, unless, as majority leader indicated, you have an economic hardship and can't. Or third, you run away. And I guess I'm just trying to wrap my head around how big of a problem this is. And again, I guess that data is very important to me to figure out. If they don't know the number, that really bothers me. Thank you, Chair.
All right,
Senator. If I could add on to that, please, Chair.
I'm sorry?
Tom Lawson, if I could respond again to the Senator, please.
Sure, go ahead.
Thank you. In terms of the probation, we look at the overall probation success rate, meaning how many people complete their supervision term versus revocation, not necessarily the distinction of honorable versus dishonorable, because that is a measurement that's beyond the control of the division. That's the will or the whim of the court. And so, yes, we do capture that, and then we'll have to get back to you, but that's not a measurement of success for the division, which is why we don't have that readily available.
Thank you, but if that brings forth the question, then if I could, Chair, then what's your recidivism?
Go ahead if you have an answer, Chief Lawson.
Tom Lawson, for the record, recidivism was the definition of that was also recently changed, and so the definition of recidivism that was worked with through multiple stakeholders is that it's the number of individuals that return to incarceration within 3 years following discharge from their supervision, and so the timeline of that, we haven't reached that 3-year period yet. So that data is still being collected to determine a recidivism rate. Our recidivism calculation is different from NDOC's. There isn't a standard one for all entities. And so I guess that's also under calculation.
I appreciate that. I guess maybe I'm just using the wrong terms since you can't tell me the percent honorable or dishonorable at this time or percent of recidivism. Then by your own matrix, what's your percentage of success or failure?
Tom Lawson, for the record, our going off of memory here, our success rate, the last 3 years we've trended well above the national average for discharge success rate, and I would have to confirm it, but I believe our latest one was around 86%.
Thank you, Chair. Thank you.
And I believe Senator Pickard also had a question. Go ahead.
Thank you, Madam Chair. And I appreciate our majority leader's line of questions. As an expert, it was clear she knew the details and covered much of my concern, being I don't practice in this area. But I just want to make sure I understand your conversation in a non-expert's way, and that is that right now the judge sets the conditions of probation, and the department then decides whether or not that person has adequately adhered to those conditions. But that it sounds like most of the time, even though it's within the department's power to add that detail to the current pre-sentence investigation reports, or the rather not PSI, but the I forget what the term was, but the reports that go to the court summarizing the performance of that person, of that inmate, and that you don't currently, even though it's within your power to do so, you don't currently include that information. So even though the division itself is deciding whether or not it's an honorable or dishonorable, by removing that, we're actually removing what sounds like a pretty critical piece of information to the court. So if it's currently within the division's power to include that information in the report, but the department isn't, and now we're eliminating the heading, as you referred to it, dishonorable or honorable discharge, it seems to me that we're no longer going to be holding these people accountable for following the court's conditions of probation. So how is it that removing this, and maybe I've got that wrong, so correct me if my underlying understanding is incorrect, but that then leads to the question, how is it that this does not lower the level of accountability for these probationers?
Thank you for the question, Tom Lawson, for the record. So I believe there is a little bit of a misunderstanding on I guess, the overall system. So there's two different sides. On the parole side, I'll address first, is that the parole side, the parole board establishes the terms and conditions of release. Then the offender comes to the division for supervision, and then at the completion of the parole term, then the division makes a determination under statute of whether they've honorably or dishonorably completed their parole, and under statute, the division issues that discharge. There isn't a report to anybody else. There is a discharge report completed, but we advise the parole board of the discharge and the distinction. For the probation side, the district court sentences the individual to a term of incarceration. That term is either deferred or possibly suspended, and then they impose conditions of supervision with a probation term in lieu of incarceration. And so in that regard, the division monitors their performance, and then at the completion of the supervision term, we write a discharge report back to the court where we define and outline their responsivity to supervision. Did they attend their court-ordered, supervision, or counseling and things like that? And so if you have somebody who's been non-compliant the whole time, well, there would have been violation reports that the court got beforehand, and a package and path along their supervision of intermediate sanctions and things that have been taken into account and applied to this person to try to gain compliance. And so at the end of that, you have a discharge report, which provides a summary of their adaptability to the terms of supervision, and ultimately the recommendation, because that's what's required in statute, is they've either met the terms or the requirements for an honorable, or they haven't met the terms for an honorable, and therefore it becomes a dishonorable discharge. And that's as a recommendation to the court. And ultimately, the court is the decider of whether, in their view, that person deserves an honorable or dishonorable. And so the disconnect that Senator Cannizzaro brought up is that sometimes in a subsequent pre-sentence investigation report, that there isn't that previous supervision instance specifically defined. And I can see her point to that. Thinking about that process is that this is focused on the current violation. There is reference back to previous convictions in terms of supervision. But because that distinction was there, that was kind of the answer at that point, was honorable or dishonorable. But certainly moving forward, and I made a note of it today, that should this proceed and that distinction be removed, well, then we have to do a better job of ensuring that information is in a subsequent pre-sentence investigation report. And for those items that she's absolutely correct also, that not every subsequent conviction would require a new pre-sentence investigation report. There's a threshold, as she mentioned, for certain crimes wouldn't be, let's say, severe enough to warrant a pre-sentence investigation report. There are also time elements. If the court accepts the previous pre-sentence report and it's within 5 years of the previous instance of a pre-sentence investigation, then the court doesn't have to order a new pre-sentence investigation report. So there are those times in there. And what we're saying is that in those instances, we are documenting the details of the previous supervision instance in that discharge report. And so in the times when there's that gap between when we change procedures to ensure that information is in a new pre-sentence investigation report, or for times when there isn't a new pre-sentence investigation report, we would ensure that the court and the prosecutors had access to the previous discharge report where that same information would be. And so to better the process, we ensure that it is sufficiently detailed in the exit report for the previous instance, and also duplicated in a future pre-sentence investigation report. And I believe that combination ensures that in all cases, the information is available for those decision makers should there be future crime and sentencing.
All right, thank you for that. And for somebody who likes to spend time in the weeds, I think we went in pretty deeply. But at the end of the day, my concern is this. And you brought up the conversations we've been having, I mean, since I've been in the legislature, about restoration of civil rights and how the terminology of dishonorable versus honorable discharge will have an effect on that. I mean, this has been in our discussions in this committee for many years. But the key that I think we hit on each time we discussed it was the fact that we're talking about accountability of somebody who is either voluntarily committed to following the conditions of their probation or not. And by removing this language, I think we are removing an important label, even though it may just be that. As to whether or not, because as you pointed out, at some point their term expires, and at some point the division has to make the determination whether or not they followed, or did they follow or did they not substantially follow the rules. And it's certainly within, my understanding, correct me if I'm wrong, but isn't it within the jurisdiction or within the discretion, rather, of the division to determine whether or not some, maybe the early violations, particularly when we're talking about addiction recovery, and we know that relapse is a part of that recovery, but over time they improve. Isn't it within the division's discretion to kind of not waive, but consider but disregard to some extent the early violations, whereas if they come into compliance and remain in compliance and they turn out to be doing exactly what they need to be doing, then they're deemed an honorable discharge. I don't see how that's outside of the division's discretion to provide. If somebody's doing a good job under the circumstances, give them an honorable discharge. Isn't that within your discretion already?
Tom Lawson, for the record, on the parole side, yes, that is, and that is our current practice. On the probation side, we are merely the reporter and recommender to the district court for their determination. And so in that discharge report for somebody who did have those hiccups at the beginning and was successful and able to be compliant later in their term and can complete that, and in those cases, yes, we would outline both the good and the bad, and the ultimate recommendation would be, as warranted, recommend honorable discharge. Then it's up to the court to make that determination of, the element whether they earn it or not was, in the court's view, did those hiccups amount to a dishonorable, even though they've corrected the behavior? And that's hasn't been and would not be a part of the division's purview, even with the changes.
All right, thank you for that. And so I think you've established that while this may make it easier to handle by eliminating the distinction, it's ultimately up to the court and it's within your discretion to decide whether or not the person has done a good job under the circumstances or not. And so I think that's an important measure of accountability. In any event, I appreciate your detailed responses. I'll go back and review them and make sure I understand them. But thank you, Madam Chair. I appreciate it.
Sure. Senator Harris, did you have a question?
Thank you, Chair Scheibel. My question has to do with this concept of economic hardship. Can you talk a little bit about the division's process in determining whether an economic hardship exists or not?
Yes, Tom Lawson for the record. So as part of the supervision term, the division looks at the judgment of conviction to determine what restitution is ordered, if any, by the court. And on average, it's about 30% of our supervised offenders have some degree of restitution ordered by the court. And so we look at the amount of restitution that's owed. We take into account the statute that requires the offender to pay a supervision fee to the state for each month of supervision. We look at DNA collection fees that may be ordered by the court. And we take all those amounts that are owed under the judgment of conviction, and then we look at the earning potential of the individual during supervision. And so, as I mentioned before, if we have somebody who's on for a year of supervision in a probation case, we'll say, and they owe $100,000, then we look at that and say, okay, well, in order to pay off your restitution within that period, you're going to have to make a payment of just over $8,000 a month. On top of that, we add in this. And then, the realization is probably less than 1/10 of 1% of the supervised individuals can afford that while putting a house over their head, food on their table, clothing on their children, and taking care of the normal, security elements and health and safety elements for their family. And so if the person has a decision to make of whether I pay restitution or I feed my children, that seems to be an easy decision that any parent would make. I'm sorry to the restitution person, but you're probably not going to get money. And so the division is not a bill collector. We work with the person because their long-term rehabilitation and integration into society is our primary guiding factor there. And so if they can only afford to make a $50 or $40 a month payment towards that restitution, then that's deemed what they're capable of doing based upon looking at their monthly expenses and their monthly income. And so in those cases there, even though they're not going to really make a dent on their restitution during their supervision term, we would deem that a successful attempt to pay their restitution. They're making an effort towards it within their means while taking care of their family. They're showing positive behaviors by budgeting and things like that. So all those things are taken into account. And so in that circumstance, they may not actually earn good time credits because they're not capable of making the restitution payments fully. But that would go towards in consideration, I guess, under that economic hardship part of it, of why they did not complete their restitution payment within the supervision term. And now the civil confession of judgment isn't necessarily a thing for new convictions anymore. It's kind of wrapped up into the judgment of conviction. And so that civil law obligation post supervision term is wrapped up in the judgment of conviction. So there isn't a separate civil confession of judgment for new cases anymore. But that's still a civil obligation that they carry with them in the future, although they may be discharged from supervision. And so the division, even though we're not obligated to work with that person after discharge from supervision, we still do. We have a number of offenders who are discharged but still make monthly payments to us towards their restitution, and we collect that money and pay it out to the victims as if they were still on under supervision. And I hope that addresses your question.
It does. I think that's the answer I was looking for, but I guess I'm a bit confused as to why we still have folks who are getting a dishonorable discharge because they couldn't afford to pay their restitution, if the economic hardship is working in the manner that it should. So what are some people falling through the cracks? Did they just not apply? Right? Why are we ending up with some folks who, as small percentage as it may be, but any person who is getting a dishonorable, even just because they, could not feasibly pay?
Tom Lawson for the record. I believe that's just a individual interpretation by the deciders of fact. Some courts would look at that payment and say, okay, you did what you could. That amounts for me as that one judge as qualifying for an honorable. And there are others that are very stringent in their stance that if you didn't pay 100%, then you get a dishonorable. And there's variety in between. I don't know how to address that and apply it universal across all of the district courts and each department within the district courts. But each judge makes a determination upon their standards of whether a successful completion of a payment plan, even though it may not be 100% restitution payment, would qualify as meeting the terms of supervision for their court.
So, under Section 2 of the bill, NRS 176A.850, it makes it clear here, economic hardship verified by the division. And so are you suggesting that there are courts, even though someone may have had an economic hardship verified by the division, is still giving dishonorable discharges based upon failure to pay restitution?
Tom Lawson for the record. Throughout the full language of the statute says that economic hardship as demonstrated to the division is the decider for whether the division makes a recommendation for a honorable or dishonorable discharge. It doesn't place a specific burden upon the court to agree with our recommendation.
Okay, understood. Thank you.
Thank you. I also have a couple of questions, and I'll work backwards from my colleague's questions, starting with the issue of people who have an economic hardship preventing them from paying restitution that is then preventing them from getting an honorable discharge. And if that is happening, that is extremely concerning to me because it's not supposed to be happening. And I'd be interested to understand what jurisdictions that's happening in and perhaps why, and see if there is a fix that can be made to the statute to prevent that from happening in the future. And I'm going to launch into my other questions because I want the presenters, as well as anybody who's going to be testifying in support, to hear directly from me what it is that I don't understand about this bill. And I'm just going to be very frank with you about the concerns that it raises for me and the analysis that I'm trying to do of the philosophical proposition here. Because what we're talking about is that a person, and we'll set parole aside for a second because it's different, but a person's on probation who has committed a felony and they are not being sent to prison, even though they have an underlying prison sentence, because they're given the opportunity to do probation instead. Sometime at the end of that person's probationary period, or sometime in the middle of that person's probationary period, they come before a judge for a determination as to whether or not they will continue on probation, or whether they will be discharged from probation, or whether their probation will be revoked and their underlying sentence will be imposed. So I understand that for that person, there are, the way I see it, and again, I want anybody who disagrees to explain to me why and how. The way I see it, that person is in the middle, and there are three different possible dispositions of their case. Best case scenario, they are honorably discharged from probation. Worst case scenario, they are revoked and sent to prison. Right now, there is a middle ground, which is a dishonorable discharge. And we are talking about taking that middle ground away. I understand that before the 2019 session, there was a very drastic difference between an honorable and a dishonorable discharge, and that was the restoration of civil rights. And that, frankly, was wrong. It's not good policy. Nobody's civil rights should not be restored because they got a dishonorable discharge. But we fixed that in statute. So what I want to understand is why we're going to get rid of that middle ground of dishonorable discharge and force every judge, prosecutor, defense attorney, and defendant into the position of only having discharge or prison, because I have seen cases where an individual is given the choice between continue on probation, complete West care, complete inpatient drug counseling, pay an additional $1,000 restitution, and you get an honorable discharge and you don't have to go to prison. Or you can take the dishonorable discharge today and have your case closed. And that would no longer be an option for that person because we're getting rid of the dishonorable discharge. And what I want to understand is for that person who today could get a dishonorable discharge and walk out of court with their case closed, but have that signal to a future prosecutor, a future defense attorney, a future judge, that last time I was on probation, I didn't fulfill all of my obligations. What are the collateral consequences that they're currently facing that are unfair that we would be preventing by getting rid of the honorable and dishonorable discharge distinction? So I will start with you, Chief Lawson, and then I think that will be my only question.
Thank you, Tom Lawson, for the record. I guess to relate this back to your kind of workflow, yes, the worst case scenario is discharge, is revocation and imposition of the underlying sentence. Instead of there being, honorable versus dishonorable choice, the ultimate choice is discharge. So your flow chart still works. It's either revocation on one end of the spectrum, discharge on the other. And then I guess if we're looking at systemically or systematically, it would be if discharge, then honorable versus dishonorable. So the discharge decision is the same moving forward as it is now. It's just, again, what is that distinction? And I guess going back to, what is that reward for the person for doing that in terms of a future case? The facts and circumstances are the same. They may only get a piece of paper now that says discharge, assuming this were to go through. However, in that future consideration would be the success factors that they had in that underlying or the previous supervision instance. And that's what we're committing to. And again, willing to codify is that the content of the discharge needs to have these elements into it. That's acceptable. We want the prosecutors to have the information to decide whether they should take that previous instance of success into consideration, or they should take that previous instance of supervision failure into consideration and argue against probation in the future. We think that's a very important tool for the courts and the prosecutors, and we're not in any way, shape, or form trying to take away that. We want the prosecutors and the courts to have the best information to do that. And I guess the stance that keep coming back to is that one word is not the best information in all cases. The outlined facts and circumstances that we provide in that discharge report and are committed to providing the discharge report and to repeating now in a future PSI are the true meat and potatoes of the foundation of your future decision making.
So maybe my question wasn't clear then, because I understand that the benefit retrospectively of being able to see the facts and circumstances of a person's previous experience on supervision and their discharge, you want that to remain the same. You want the judges, prosecutors, and defense attorneys to have access to information about how the person performed on probation previously. But what you want to get rid of is the label. Whereas today, what the label is useful for is in that moment when a person is facing revocation, they currently have an escape hatch. They can get a dishonorable discharge and go home and not to prison even after they've violated their terms of probation. So if you're going to be providing all of that information on what happened at the hearing, what the violations were, how the person ended up before the court anyway, why wouldn't you want to leave them with the option of taking that dishonorable discharge on the day of their revocation hearing?
Tom Lawson, for the record. I don't know, maybe the other voices that have a better opinion on that than I. Yes, the decision is still you accept a discharge now, or you continue your supervision, or you revoke. I guess I'm maybe I'm not grasping the question properly to give it justice.
And I'll just make one more clarifying question, and then we'll move to testimony. But, you know, I go into these revocation hearings with probation officers, and I sit down with them beforehand and have a conversation about how the person is doing on probation. And sometimes, in fact, sometimes the perspective of the probation officer is that this person is no longer supervisable. They might not be violent, they might not be engaging in serious criminal activity, but they might just be no longer able to be supervised. They never call me back. They can't keep a job. They aren't paying their restitution. They pick up small misdemeanor crimes. They've been arrested again. Maybe it's not a person who needs to have their suspended sentence imposed, but it's a person that the Department of Public Safety no longer wants to supervise. And so if the Department of Public Safety no longer wants to supervise somebody and we cannot give them a dishonorable discharge, are you going to start supervising them anyway? Are we going to implement programs that give parole and probation officers better tools to supervise unsupervisable people? Or are we going to accept that some of those people are simply going to have their suspended sentences imposed?
Tom Lawson, for the record, I think those tools were put into place. Some of those tools were put into place under AB 236. Now we have the temporary revocations, which were a brand new tool for our toolbox, just started again. And you know, we have a number of instances where people are already on their third tier of temporary revocations. And so we had graduated sanctions before graduated sanctions. You know, I like to say we had it before they were cool and under AB 236. We started those in 2017. Before 2019, we were required to. And so our adaptation to the temporary revocation was we just worked it into our existing matrix, and it was business as usual. So we have some of those tools in place, and I think the temporary revocations were an excellent tool along those lines where, okay, you're not compliant. We've tried curfew, we've tried extra counseling, we've tried check-ins, additional check-ins. You've worked up the sanction matrix, and now we take them back for the court. We lay it all on the table, and the court says, okay, there you go. Now you're going back into jail to, you know, let you know we're serious about this. The parole board has, on a number of occasions, have imposed their third tier, the full 30-day temporary revocation on people for multiple violations of that. So that tool is in place, and ultimately, if they're truly unsupervisable, then they're the candidate for revocation after the graduated sanctions. I wouldn't agree that there should be an option for the division to say, I don't want to supervise this person anymore. If the courts order them to supervision, then we supervise them, and we supervise them with all the tools that are at our disposal. And then it's our responsibility to paint that picture for the court of why they're not supervisable, so that when we go for the revocation hearing, then the court can decide, do we revoke them or do we return them to supervision? If they get returned, then we continue the process. And if they continue to be non-compliant, well, they've already exhausted many levels of the graduated sanction matrix. We'll just bring them back to court quicker, but we're not going to check in. We're not going to not supervise them because it's inconvenient or they're just not going to comply. We're going to use the tools at our disposal throughout the period of our authority over them.
All right, thank you. I think Senator Orangel had another question. Go ahead.
Thank you,
or
Chair.
A question.
Thank you, Chair, for the indulgence. Just a couple of real quick questions. Going back to the economic hardship factors, what does the division, do they have set factors? Do they look at the income of the person being supervised, whether they've got steady work or whether they're doing day labor? I mean, what kind of things do they look at in terms of whether that might make them have a negative termination or not?
Tom Lawson, for the record, we look at all that. If they don't have a job coming out, then we put them in touch with Dieter. We put them in touch with work programs and ways to find themselves a steady job. And if they have a job and it's not quite meeting their bills, well, we help them try to find a better job. Do they qualify for veterans benefits? Do they qualify for programming through different options to try to find solutions that provide long-standing benefit to them? It's not a matter of you come out, you're unemployed, do you qualify for social services and things like that. We want to instill in the offender long-term success, and part of that is stable work and the ability to maintain a job, because once you have a job, then you can, and the ability to maintain a job, because once you have a job, then you can feed yourself and you can provide shelter for yourself and your family. And so all those things are a factor. And so, the initial budget, we looked at their cost versus their income. That may change. If they go get a better job, then we reevaluate what they're able to pay towards their restitution. Like I said, we're not bill collectors. We're not going to shake them down to get every penny out of them. The goal is long-term stability and rehabilitation of the person throughout the rest of their life, not just collection of restitution by any means necessary. Part of taking responsibility is meeting your financial obligations. And so that is an element we look for and, work with them on for their long-term stability and rehabilitation. But again, we look at every factor they have. Are they receiving family support? Are they staying with the family? Well, if they're staying with the family, there's probably less rent involved, which means that their income level would go farther for quote unquote discretionary expenses. And so, if they have a lot of discretionary expenses, we talk to them about cutting those down and paying more towards their restitution and their obligations. But everything is a factor of those discussions.
Thank you very much, Chief Lawson. Thank you, Chair.
Thank you. And with that, we are ready to move on to testimony. I believe we do have people here in person to testify. So we will call the first person up to the table to testify in support of AB 17.
Good afternoon, Madam Chair, members of the committee. My name is Holly Wellborn, Policy Director for the ACLU of Nevada. Would you like me to spell my name on the record? Great. I want to just, I want to use an example. So there were a couple of questions, and I think I can address two of those with an example from intake that we received. The first is the question of whether or not the economic hardship provisions actually provide, this type of cover that we think it does. And then also to talk about the collateral consequences of what it is to have a dishonorable discharge on your record. So we had one intake. This was a gentleman, he made quite a bit of money. He did have a meth addiction. He was put into a drug court program. He was dishonorably discharged because he made too much money. He didn't qualify for economic hardship. They had to graduate him out of that drug court program. It went back to his sentencing judge, and it was they determined dishonorable. The consequences that has had for his life, he's, it's dishonorable, so he's no longer responsible for paying that restitution, which I don't think is, we want to be the public policy of the state. And two, he had a young daughter. Because he had the dishonorable discharge on his record, he was unable to participate in after-school programs and to take her on different school trips because there was this dishonorable discharge on his record. So I think, when we think about it in terms of that, it has severe consequences for employment, severe consequences for other opportunities that could be available to a person that they're otherwise not able to get because they have that status of discharge. So I just want to say thank you to Chief Lawson. There are a lot of questions that have to be answered here, and I think what we're looking at is some deep dive policy decisions that we have to work on making in the future. But I think that this was a great start, and that the line between honorable and dishonorable discharge has been thinned, given the restoration of civil rights and different policies that this legislature has considered. So I do encourage the committee to continue this conversation. And again, I want to thank Chief Lawson for reaching out to us, I think exactly 1 year ago today, to start talking about this bill. Thank you.
Thank you. Looks like we have one more person to testify in support of AB 17 in the room. Please go ahead whenever you're ready.
It's been a while since I've had to do that. Thank you, Chair. Marcos Lopez, Americans for Prosperity, Nevada. So one of the main reasons we're supporting this is because we support expanding the access to discretionary discharges, to record ceilings. And if we look at NRS 179.2445, the dishonorable discharge makes it more difficult for individuals to be able to seal their records in the long term. And we support in sealing these records because we believe that individuals, after a certain amount of time, if they're able to prove to a court that they have made an effort to rehabilitate their lives and that they've made an effort to become a functioning member of society again, that they should be able to have their records be sealed, and they should have the same amount of process as everyone else. Currently, in this NRS, the rebuttable presumption makes it a harder barrier for individuals who do have that discharge on them. So that is one of the main reasons we support this, as well as the fact that we are the only state that makes this distinction in the entire country, and we don't necessarily believe that it contributes much in helping make those judgment cases. In fact, it's probably too binary in being just honorable or dishonorable. So, I mean, we do support, if to kind of Zero said, of making sure that we provide all that evidence to the judge and to the court to be able to make those decisions. And, you know, that's the main reasons why we're supporting this. And, you know, hopefully everyone comes out and supports. And if we can make some of those changes, I think it'd be a very positive impact for individuals all across the state. Thank you.
Thank you. I believe that concludes our in-person testimony, so we will move now to testimony by phone in support of AB 17.
Thank you, Chair Scheib. To testify in support on Assembly Bill 17, please press star 9 now to take your place in the queue. Once again, to testify in support on Assembly Bill 17, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 080, please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Hi, Jim Hoffman representing Nevada Attorneys for Criminal Justice. We support AB 17, and in addition to the points made by the bill's proponent, I'd like to discuss Chair Scheibel's question because I think that's a really helpful framework for thinking about this issue. I have 2 points that I would make in support. The first is, like Ms. Wellborn, I also have a real-world example of how the current statute hurts people. I have a friend from high school who developed a drug addiction in college, and he was convicted of drug possession. He got put on probation for it, and he did everything he was supposed to. He went into treatment, he got clean, and he otherwise fulfilled all of his conditions. But he was a broke college student at the time, so he couldn't afford to pay all of the fines and fees that he had. His probation officer told him, "I don't think you're any danger to reoffend, so I'm just going to dishonorably discharge you now, and you can worry about paying the fees later." So that's what happened. My friend got dishonorably discharged, and he did pay the fines and fees. But the problem was, he still had that on his record. So when he was applying to grad schools, he got rejected several times because they saw this on his record, wouldn't accept him. He eventually got accepted to an English grad program, but this is the kind of trouble that dishonorable discharges can cause. And again, my friend did everything right, except he was poor. That's the kind of problem that we're causing under the current statute. The second point I would make is that, as Chair Scheibel said, dishonorable discharges are a middle ground. But I think the implication of that is that a dishonorable discharge isn't really a good signal to a judge about a person's fitness for probation. Because if a person is really bad at probation, they don't get a dishonorable discharge. They get picked up and they get put back in prison and they expire their sentence. So what signal is a dishonorable discharge sending? It's not really saying that a person's going to be bad at probation, because a lot of these cases are like my friend. They're cases where the person did everything right, they just couldn't pay. So if we keep this framework of honorable discharge and dishonorable discharge, the main information we're providing the judge is that this person is too poor to pay their fines in most cases. I don't believe that's a useful kind of information for judges, and I don't believe our statutes should reflect that. So to sum up, NACJ is thankful to the division and the bill's sponsors for bringing AB 17, and we support its passage. Thank you.
Thank you, caller. Caller with the last 3 digits, 318. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Good afternoon, Chair Scheibel and members of the Senate Judiciary Committee. This is Kendra Birchie, Kendra, Bertschy, and I'm testifying on behalf of the Washoe County Public Defender's Office as well as the Clark County Public Defender's Office. I first want to thank Captain Lawson for bringing forward this bill. We agree that it provides additional conformity and consistency within our laws. And more importantly, we agree with his statement that currently we do believe that we are relying sometimes on misleading information. I want to start by first clarifying some statements regarding restitution. I do not believe that this bill is trying to say that an individual should not pay restitution or is trying to work with a way to have them prevent it and still receive a favorable probation outcome. If someone is not able to pay restitution by the time that their period of probation ends, they would sign a civil confession of judgment. So I don't believe that this is precluding people from being able to receive restitution. Regarding the statements that this bill would remove accountability from someone who is unsuccessful or not completely compliant with probation, I just want to remind the committee that if someone is not compliant with their probation, there are those sanctions that will be imposed. There would be a revocation hearing, and if the court decides that they are not complying, then that sentence would be imposed and they would be sent to prison. I think that's important to note that that would also appear on their record, and that would help in terms of if there's any future discussions about the probationary status, that would be very evident in that pre-sentence investigation report. I appreciate Captain Lawson's statements regarding providing additional information on someone's probationary status and their period if there's any future violations, because that's something that we don't currently always have access to. Sometimes we get information about ways that they failed in that pre-sentence investigation report, but we also don't get the ways that they succeeded, the times that they were successful in an inpatient treatment program or that they did comply. So we do appreciate that the system has changed to allow for that. There are some conversations for negotiations or at revocation hearings, different abilities to request a discharge. I would just note that it's very apparent, especially in the conversations of this bill, that our prosecution and defense attorneys are negotiating and handling cases in different ways in different jurisdictions. So I do appreciate those statements, and I believe that NRS 176A.630 can provide some guidance with the different tools that we do have in our toolbox in order to work with individuals to try to, if they're not being completely compliant, to bring them back on board. With that, I would just note that the honorable and dishonorable discharge has a huge impact on our clients, particularly with housing, where sometimes clients have to prove that they received an honorable discharge in order to be able to obtain housing. And so we do believe that this bill will have a huge impact on the lives of our clients, even if they are not involved in the criminal justice system again. So thank you, and I appreciate your time.
Thank you, caller. And with that, Chair Scheibel, there are no more callers to provide support testimony at this time.
Thank you. We will move to testimony in opposition to AB 17. There's nobody present in the committee room to give testimony, so we'll go straight to the phones.
Thank you, Chair. To testify in opposition on Assembly Bill 17, please press *9 now to take your place in the queue. Once again, to testify in opposition on Assembly Bill 17, please press *9 now to take your place in the queue. Caller with the last three digits, 527, please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin. Once again, caller with the last three digits, 527, please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin. Once again, caller with the last three digits, 527. You are unmuted. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin. Alrighty, we will move on. Caller with the last three digits, 648. Please press star 6 to unmute yourself. And slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Thank you, Chair Scheibel, members of the Senate Judiciary Committee. My name is John Jones, John Jones, here on behalf of the Nevada District Attorneys Association in opposition to AB 17. I do want to thank Parole and Probation for meeting with us to discuss this bill. As district attorneys, we truly value the work that Parole and Probation does to both protect our community and to assist in the rehabilitation of offenders. The DAs believe that AB 17 would remove a layer of accountability for defendants who complete community supervision. Having the designation of honorable or dishonorable discharge both serves as an incentive for those currently under community supervision to do their best, and also serves as a reference point for those in the justice system should the defendant reoffend in the future and request probation again. While the courts issue the discharge, in virtually all cases, they follow the recommended discharge from Parole and Probation. Additionally, as was alluded to by Chief Lawson, current plea negotiations in Clark County specifically have been built around the honorable, dishonorable designation. You will regularly see a negotiation where a defendant may earn a reduction in the charge to which they pled, meaning they can withdraw their plea to a felony and plead guilty to a gross misdemeanor or misdemeanor. The trigger for this reduction in the guilty plea agreement is whether the defendant received an honorable discharge from probation. In this way, all parties have essentially agreed that probation will act as the third party to determine defendant's success or failure on probation, and losing this designation would cause extensive litigation. Crafting a solution that takes into account these cases is essential to us. Finally, we have become aware of some inconsistencies surrounding implementation of these discharges as applied to the various defendants. A better solution would be to fix those inconsistencies. Potentially, we could add a general discharge option for those defenders who do not easily fit into the honorable or dishonorable designation. But either way, we look forward to working with PNP and Chief Lawson specifically on making the current system more equitable rather than discarding the honorable, dishonorable designation altogether. Thank you for your time.
Thank you, caller. And with that, Chair Scheibel, there are no more callers to provide opposition testimony at this time.
Thank you. We will move to testimony in the neutral position. I'm wondering if Ms. Gonzalez is still with us on Zoom and if she wishes to give neutral testimony or if I missed you in a previous position, in which case I apologize.
Good afternoon, Chair. Thank you so much. No problem. For the record, Victoria Gonzalez, Executive Director of the Department of Sentencing Policy. I am here to testify in support of AB 17. Our department assists the Sentencing Commission in developing data-driven recommendations for sentencing corrections. And over that time, we have developed partnerships with various criminal justice agencies, including Chief Lawson at the Division of Parole and Probation. And one of the things that our understanding of the bill is that the impact is neutral. As far as what Chief Lawson testified to in regards to AB 236 and those additional, the technical violations and those temporary revocations and the graduated sanctions that are in place to offer those additional opportunities. However, because our agency is data-driven, we also want to make sure that the legislature knows we are here to support, along with Chief Lawson, in collecting that data that's going to be really important to determine what are the outcomes of legislation like this. And so I think a lot of the questions that came up are things that we'll be able to assist with in the future as we partner with Chief Lawson and his team in determining the actual impacts of this. And so we can help the legislature and the agencies evaluate whether the impact of this is neutral as it was intended, or if there ends up being other consequences. And as we work with the other criminal justice agencies, we work with everybody, we can figure out what all those impacts are, not just the fiscal impacts, but the policy impacts and the practical impacts of making a change like this that has one intent, and we can help evaluate whether or not that intent is actually able to be realized in the end of the legislation, and that's what we hope to offer. But again, Victoria Gonzalez, for the record, testifying in support as far as our understanding and support and collaboration with Chief Lawson, that the intent of this is to continue to promote the effectiveness of the criminal justice system and their supervision, and as it is complementary to what was enacted in AB 236 with those graduated sanctions and temporary revocations. Thank you.
Thank you. And so if the record could please reflect that Victoria Gonzalez with the Department of Sentencing Policy is in support. Thank you. And now we will move to testimony in the neutral position. There's still nobody to give testimony in the room, so we will go directly to the phones, please.
Thank you, Chair Scheibel. The phone lines are open and working. However, there are no callers at this time.
All right, then that concludes our hearing on AB 17. I will now close the hearing, and that takes us to the last item on our agenda, which is public comment. I don't see anybody in the room to give public comment, so we'll go to the phones. Mr. Kyle, could you see if there's anybody who wishes to give public comment?
Thank you, Chair Scheibel. We are currently on public comment. If you'd like to provide public comment this afternoon, please press *9 now to take your place in the queue. Once again, if you'd like to provide public comment at this time, please press *9 now to take your place in the queue. And Chair, the phone lines are still open and working. However, there are no callers at this time.
All right, then that is a wrap on this meeting. We will be adjourned until tomorrow at 1 p.m.